All right, our next case, or cases, SAWGRASS Mutual Insurance Company versus Terry and Diane, is it MONE or MONE? MONE, thank you. All right, there's two cases, 1569 and 153061. Same counsel on both cases. We are inclined just to do it as one conglomerate here. That being said, is there any, do you each believe you need to hold 40 minutes for both, or is 30 minutes acceptable? I don't want to cut anybody if they think they need more than 40, but based upon the specific issues that have been raised.
Your Honor, on behalf of the appellant, we are fine with less time. We will not need all 40 minutes. I think 30 minutes for both would be sufficient if it pleases the court. And then we'll
Mr.
just...
Nation, are you okay with 30? Okay, thank you.
And then if it also pleases the court, we'll just go directly into that component of the argument without,
Right,
straight through.
that's why we're giving it together here, so that you...
Thank you, Your Honor.
Okay, go ahead, counsel, whenever you're ready.
Thank you, then. May it please the court, Jack Ryder on behalf of SAWGRASS Mutual Insurance Company, and I'll reserve 5 minutes for rebuttal, or I guess in this instance, Your Honor, I'll take 7 minutes in light of the fact that we've got two separate components of the argument that are being presented.
7 minutes.
Thank you. Let me start then, of course, with the primary issue on appeal, Your Honors, and that is, as a matter of law, we believe the court here should reverse and remand for a new trial because SAWGRASS Mutual was not allowed to introduce the full unredacted report of the neutral evaluator or to present his unfettered testimony from the perspective of him being recognized and identified before the jury as a neutral evaluator. And it is our position that this is a de novo...
What's the standard?
Yes. This is a de novo standard, Your Honor. It is our position it's de novo because under the statute, as applicable in this case, this, section 627.704...
The statute doesn't address how an expert is referred to at trial. It seems that this is really a discretionary call for the trial judge to make, and therefore it should be an abuse of discretion standard.
Your Honor, I would respectfully disagree, and I would submit that's a de novo standard, but I will also address the abuse of discretion standard because I believe reversal is warranted here in either case. But I'd like to start and focus as to why it is a de novo standard. The statute as amended and is applicable requires that the neutral evaluator's testimony, recommendation, and full report be admitted before the jury. Full report. Let's start with the full report. Here, it was not the full report. The report was redacted. It was redacted to remove any references to Mr. James's role as a neutral evaluator. So if we look at it from the perspective of interpreting and enforcing the statutory mandate, and of course it's a poll star of judicial principles that the legislative intent is garnered from the words used by the legislature, and it is the function of the judiciary to fulfill that goal. Here, the language of the statute says testimony, recommendation, and full report. Now, here, the trial court...
Yeah, so if in a criminal context and an evaluation is ordered of a defendant and it's a court-ordered evaluation, are we going to inform the jury that this is a court-ordered evaluation, or don't we simply let the witness testify to whatever the witness is going to say?
Your Honor, I don't think that analogy applies in this instance here. This is a completely different statute that is based upon alternative dispute resolution. The legislature describes the function and reason for the idea of a neutral evaluator to facilitate the resolution of these claims. The legislative intent here was to make clear that there is an intent to resolve these disputes. And if the neutral evaluator's recommendation...
Let's assume that we did that and they wanted to put evidence on that there's really nothing neutral about this person.
Your Honor...
Can they do that?
Well, Your Honor, certainly in the context of cross-examination, I imagine that the counsel is entitled to challenge the neutral evaluator, but, Your Honor, the statute makes clear that there are very specific guidelines as to what a neutral evaluator is. It's not the court's function... I'm sorry, you were asking a question, Your Honor? It is not the court's function to second-guess the wisdom of the legislature in enacting a specific methodology for bringing these kinds of cases to resolution, and in the absence of resolution, then making clear that the jury is entitled to be aware of the fact that this is a neutral evaluator, not retained by either side.
The statute say the jury is entitled to be aware of that.
No, Your Honor, the jury's entitled to be aware of the full report.
The
Full
statute's
report.
silent on what happens if they proceed to, it just says that they may proceed to litigate if the neutral evaluator, who's in effect a mediator of sorts, is unable, not a mediator, but I'm analogizing him to a mediator. If the parties are unable to settle as a result of his report, then the statute simply says there's no bar to pursuing the balance of the litigation if they're unable, if the neutral evaluation doesn't resolve the matter.
That's
correct?
correct. The litigation continues.
But the statute does not say, and if they do go to trial and one side calls him, he can still be called as, called the neutral evaluator or as a court witness or something of that nature.
What the statute says
Doesn't
is
say
that...
anything about what happens at trial, does it?
Well, what it does say is that at trial, the testimony, recommendation, and full report shall be admitted.
All right, so let's...
It does say that.
All right, but
And
let's talk about harm.
Okay.
The person testifies, correct?
Yes, Your Honor.
All right, so what difference, where can you point to prejudice in the fact that the report itself wasn't admitted?
Your Honor, the prejudice is extraordinary.
Well,
It's-
and may I add to Judge Cohen's question?
Let him finish.
Okay.
No, the
I
prejudice-
wanted to add to your...
Your Honor, the prejudice is extraordinary, and I would add
Well,
to
tell
that...
me what it is.
I will, Your Honor, and I'm going to point out that this also dovetails into the discretionary issue. So regardless of the standard, I would submit that the prejudice, the undue prejudice, is extreme, and here's why. This case, the concept of whether or not this was or was not a sinkhole, is entirely dependent upon expert witness testimony. There are terms are utilized and principles are used that are far beyond the purview of a layperson, beyond the purview of an attorney.
That's why the witness was called and testified at trial.
That's right, Your Honor.
So let's try to get to the...
So the issue, Your Honor, the primary way under 90.608, maybe not the primary, but I would certainly say one of the critical ways of demonstrating bias or bias in the context of an expert witness or any witness is if there's a financial relationship between the expert and the party calling the expert. And I would suggest to the court that when we look at, and there's many cases that stand for the proposition.
I'm not hearing your answer to the question of prejudice. I don't know, are you going to get to that?
Oh, Your Honor, I would respectfully
Then
suggest
get to it.
I will answer it even more directly. The prejudice, Your Honor, is that by requiring SAWGRASS to call Mr. James and precluding the interpretation of the statute, precluding us from recognizing him as neutral.
No, the question was about the introduction of the report.
Okay. Yes, the fact that the report says along the top, neutral evaluator's report.
So we go back to the fact that...
It's all about neutrality.
Okay, all right. Then
That's
the report itself, his testimony covered everything in the report. Your problem is that it's the title of neutral.
That is it, Your Honor.
Okay.
It's all about neutrality.
Okay, all right.
So,
And-
but didn't the trial court level that playing field by saying neither party could ask about his payment? And isn't that usually a pretty powerful...
Neutral
point?
thing?
Yeah, and that neutralizes it, because aren't experts normally grilled on how much an hour, a minute, a second they're making by sitting on the witness stand?
Your Honor, I don't think that that's sufficient here. I don't think that that ameliorates the prejudice, because it's not simply our inability. It's not simply about cross-examining an expert to identify bias or prejudice based upon a relationship. It's here that there's a legislative mandate that describes the importance of the neutral evaluator's role, and we were precluded from highlighting that role.
So you basically, essentially, you want to be able to say, look, we've hired our experts, we've paid them, Nation's hired his experts, paid them, they all neutralize themselves. I'm all of a sudden fixated on the word neutral here. Forget about those people, jury. We got a neutral guy right here, and this neutral guy says, I win. And you want to be able to say that, and you're saying that the trial judge abused his discretion by simply saying, look, he's an expert, let him testify, you want to call him, let him put on his say, and let the jury ferret it out, and that's an abuse.
Absolutely, Your Honor. I don't, and I would like to paint it in a different manner, if I may. It's not simply, oh, this is our neutral evaluator, and therefore we should win. It's a little bit different, Your Honor. I would submit that the legislative intent has to be fulfilled, both as to the letter and spirit. The spirit of the intent here was to facilitate resolution of claims, and if the resolution is not contemplated, in other words, if the neutral evaluator's report is rejected, then the report, testimony, and recommendation shall be admitted. Now, I would submit that requiring the neutral evaluator to allow him to be admitted, requiring that as a matter of law, but then taking away the fact that he's neutral eviscerates the statute entirely. Because the whole point of identifying, the whole point of mandating that the neutral evaluator be allowed to testify is because this individual was neutral, not retained by either side. That's the legislative intent, was to make clear
Well,
that if a...
I'm sorry, that was initially, that he was not paid by either side, or they shared the cost, right? But when he came to testify at trial, who paid for his time?
Your Honor, I don't know that that's in the record. I know that that was not presented either way, as Your Honor noted. That was not presented. But I would again submit that whether we look at it under a de novo standard, as I think we must, and we talk about the fact that here the full report was redacted, and that in and of itself is a violation of the statutory language, number one. And yes, as to the words neutral evaluator. And number two, if we look at it even from a discretionary standard, I believe that it is an abuse of discretion to eviscerate a statute that expressly says that if you reject this neutral evaluator's report and recommendation, then you will go to trial, and that report shall be admitted, and so will his testimony.
Well, let me analogize, as Judge Cohen did, to a criminal context, and where the state loves to call the child who has allegedly been molested or harmed the victim. And that's really an invasion of the province of the jury, because unless and until the jury decides that the person accused is guilty of doing that, that person isn't necessarily a victim, correct? So by saying, nope, everybody has a name, call them by their names, we're not going to use labels here. Isn't that essentially what the judge did by saying, nope, they've all got names, use their names, we're not going to use labels?
Again, Your Honor, I would respectfully disagree that there was any analogy between this case and in a criminal case or or any kind of criminal proceeding where there's efforts made to shield identities or...
I'm talking about the use of names as opposed to labels.
And I'm suggesting here that the label is what makes the difference. It's not simply a label from a title. It's not just about his title. It's about his role. This is not the role of an independent evaluator, an independent, impartial individual retained by both sides, and the statute is very clear on this. Full report, testimony, and recommendation shall be admitted. Now, I do want to touch upon the fact that there's been some argument by my opposing side that the prior statute applies. And that, I would again suggest, number one, that the trial court here specifically, he did not rule one way or the other verbally, but what he did do was he denied the motion in limine that was advanced by the homeowners below that sought to preclude Mr. James, the neutral evaluator, from testifying in any way and to preclude his report entirely. The trial court heard argument on that issue, heard argument as to whether or not the testimony and report should be excluded. It was argued under the context of the prior statute applying, and the trial judge disagreed. What he did was he denied the motion in limine, and he said, I'm going to allow Mr. James to testify, I'm going to introduce his report, but then he basically undid, in my, respectfully, my opinion, based on the law, he really violated the spirit and letter of the statute by completely undermining the entire purpose of the neutral evaluation program and the significance of the neutral evaluator. So
Let's talk about your jury instruction, the efficient
Yes, Your Honor.
proximate cause doctrine. Your side's experts say absolutely not sinkhole. Homeowner side says absolutely sinkhole. Homeowner side is not saying yes, sinkhole, but also another cause. Why isn't it an all or nothing as it was presented to the jury in that fashion, as opposed to in the Salke case where the plaintiff's experts suggested that there was more than one cause to the loss in addition, the sinkhole plus?
Well, actually, Your Honor, in the Salke case, first of all, In the Salke case, and I submit that in Salke, there were experts who testified on behalf of the homeowners in that case that it was sinkhole, and experts who testified on behalf of the insurer that there was no sinkhole activity.
Well, in Selke, it said sinkhole activity and problematic soil in a reclaimed mine zone. So there was the multiple perils is what the second DCA is referring to.
Understood, Your Honor. There's, we here in this case have multiple perils identified as well. This notion that there's an all or nothing, that only has to come from the testimony of one side or the other, that is not, again, how I interpret SIBO or Salke. I mean, the concept of the efficient proximate cause doctrine suggests that anytime there's first-party coverage, like in this case, that an insurance carrier should not be required to pay for the damage to property that is claimed to be caused here by a sinkhole if it turns out that the jury finds that a portion of it was caused by sinkhole, but the greater portion of it was caused by thermal, decomposition, organic decomposition. There was testimony here on both sides that described the cause of the damage to this property.
But wasn't your expert's testimony, both of them, no sinkhole activity, period, end of story?
They found the absence of sinkhole activity, as did the neutral evaluator.
Then doesn't that go back to, so as they did the neutral evaluator, he was one of your three experts, so doesn't that go back to Judge Lambert's question that it was an all or nothing? They're saying no sinkhole, and the homeowner is saying it's a total sinkhole, and therefore, even the jury instruction on the efficient cause doctrine was kind of hedging that all or nothing stance.
Your Honor, our proposed instruction, I believe, was entirely consistent with the concept of the efficient proximate causation doctrine. We specifically said if you find that the loss resulted from more than one cause and the primary cause is not excluded from coverage under the policy, the loss is covered. However, if you find that the primary causes are excluded from coverage, the loss is not covered.
Well, how would the jury, on what evidence could the jury reach that conclusion? You have your side that says it's absolutely nothing to do with sinkholes. Mr. Nation's side, it's completely sinkhole. We, the jury, are going to come in and say, well, we believe it's both.
Well, Your Honor, it's a question of, at that point, it's a question of fact. It goes to the issue of credibility of the experts. I mean, in some ways, it dovetails all the way back to the importance of the neutral evaluator, but I'm not going to go there right now. What I am going to suggest is, under the efficient proximate causation doctrine, the fact that one expert comes in and says sinkhole, and the other expert comes in and says organic decomposition, if the jury happens to find that the plaintiff, the expert who testified it's organic decomposition is more credible, but believes that there's some potential portion of this damage that could have been caused by something other than the sinkhole or something else, then the jury will make that decision based upon who the jury determines is more credible. That's a fact question. And the fact that you have competing experts on two different sides doesn't eliminate the application of the efficient proximate causation doctrine. That's not, again, I don't believe that Salke says that in any way. It doesn't specifically say that you have to have experts, that you have to have an expert who concedes that a certain element of the damage was caused by something other than, or was in fact caused by sinkhole damage. That's not what Salke says. Salke says when you have multiple perils, evidence in the record, or evidence before the jury, reflecting the application of multiple perils that could have contributed to the harm, then the efficient proximate causation doctrine applies. And that goes directly to the question of who the jury finds most credible, and maybe the jury believes after hearing all of the evidence and hearing all of the experts on both sides, the jury might find, you know what, we believe that there was sinkhole activity here based on what plaintiff's expert says, but we think the bulk of this damage was caused by organic decomposition under the soil, as the defense expert says, and therefore we're going to find under the efficient proximate causation doctrine, no coverage. That is how I believe and I interpret the efficient proximate causation doctrine to apply in this case. It doesn't necessarily need, I don't read Salke as requiring the defendant's expert to acknowledge that, well, some portion of the damage was from organic decomposition, but maybe 1% was caused by sinkhole activity in order to apply this doctrine.
Well, let me switch gears here.
Sure.
So, as to the multiplier issue, as to the attorney fees, you're of the belief as a matter of law, based on SAWGRASS, that multiplier cannot be awarded in this case, despite Quanstrom talking about multipliers in the context of 627.428?
Yes, Your Honor.
And you concede that we've asked, earlier panels here have asked the Florida Supreme Court to revisit that, and they've chosen not to.
Yes, Your Honor.
You want us to
and the
ask
reason
them to revisit it again, just poke the old bear again?
Exactly, Your Honor. We believe that this matter remains ripe for the Supreme Court's consideration, and we would request that the court certify it yet again. There has been no decision after SAWGRASS that explicitly and directly in the Florida Supreme Court concluded that the multiplier does in fact, as a matter of law, apply in this context. This court has certified it before, and I think this is as good a time as any to certify it again if the court doesn't reverse on the primary appeal, as I believe it should.
Okay.
And of course, we are brief, as we set forth in the brief, from the perspective of the application of the multiplier under the abusive discretion standard. There was no specific testimony here that demonstrated that there was an inability to obtain competent counsel absent the application of the multiplier. And this court and others...
Well, let me ask about that.
Yes.
Let's say, okay, the Mr. and Mrs. MONE come home from a weekend and say, oh my goodness, look what happened to our house. And they turn on the TV and they see Mr. Nation's face on the television and says, hey, he looks like a guy that we need to, sounds like a very good lawyer. We're going to go talk to him about this sinkhole claim. And he says to them, okay, this is the stuff I do, one of the areas of my specialty. I'll be happy to do this, take your case on, but here's my contractual arrangement. Contingency fee, but if the court will permit a fee over and above that, I'm going to ask for a multiplier, and I'm going to put that in our contract. The Monets say, is that going to come out of our pocket? And Mr. Nation says, nope. That'll be something that's awarded separately against the insurance company if we prevail under this statute. What do the Monets possibly care about that? They've gotten their guy on the first time. It seems like on your argument that they've had no ability to retain competent counsel. Therefore, when Mr. Nation is successful at trial and asks for a multiplier, you come in and say, well, there ain't any problem getting this guy, so no multiplier. That seems like a catch-22.
Your Honor, that's not how it happened in this case.
Well, I know that, but that's how it's happening in my fantasy
So
case here.
let me address the hypothetical.
Okay.
And if in your hypothetical,
Right.
that's the way things transpired,
Okay.
then at the hearing on the motion for attorney's fees, it would be incumbent upon the lawyer who is seeking this multiplier, particularly when we're not challenging his hourly rate. It is, and that is the benchmark for complexity and all of those other issues.
Right.
It is incumbent upon the attorney to establish that absent the multiplier, there would not be able to obtain other competent counsel.
So he puts on evidence, as he did in this case. He retains counsel in the area who all say, nobody would take this case, competent counsel would not take this without a multiplier. So he's dotted his I's, crossed his T's. He admittedly does not have the testimony, or he has the testimony from the client, but the client truthfully says, well, in Lambert world, here's the first guy I saw, and I retained him because I thought he'd do a great job, and we were real happy with what he talked to us about. So you seem to suggest that that's the death knell for his claim for a multiplier, even though that he agreed to take the case with the multiplier.
Your Honor, it's not my suggestion. It's
Well, I
the
know
cases, it comes from the case law. I'll read from, Your Honor, it comes from cases such as Federated National Insurance Company out of this court, where the court reversed an award of a fee multiplier.
You rely on that case?
Sorry?
With the panel on that case?
Where the court noted it took only one phone call for plaintiff to secure counsel.
You realize who was on that panel?
I do, Your Honor.
Him and me.
That's why I'm bringing it to Your Honor's attention.
Okay.
And in that case, your court specifically found that that was the key ingredient, the key factor that was evaluated. And when it, quote, took only one phone call to secure counsel, I think in this court, as Your Honor noted, we are not required to abandon what we learned as lawyers or our common sense in evaluating the reasonableness of the fee award. We're not challenging the hourly rate, and we're not challenging the number of hours incurred. We're only challenging the multiplier. And their own witness, their own expert, specifically testified there were hundreds of lawyers, those were his number, hundreds of lawyers who do this kind of work. So, again, Your Honor, and...
You're talking about Mr. Tyler?
Mr. Tyler.
Right, but didn't he say that the majority were in the Tampa Bay area? That there was very little sinkhole activity in East Volusia County?
He did say that most of the lawyers were in that area, but he said there were hundreds of lawyers. And I'm just, again, quoting from his testimony. The multiplier is an exception, not the rule. And I think this court is, as this court is well aware, and we would submit that here, if the court elects not to certify it yet again on this legal issue, that it be reversed as under the discretionary standard. And I see I'm into my rebuttal time.
Okay.
Thank you.
All right, thank you.
Good morning.
Okay, let me get you up to the 30 before you start.
Mr. Nation, you finally have brought competent help with you today.
I did. My daughter, she was at the fee hearing also, so I thought this would be a good next step in the process.
This doesn't discourage her from going into law. Nothing will. Let's look at this statute. Judge Perkins never did rule which statute he was following. He didn't need to. He said, Mr. James can testify, the report doesn't come in. And under the 2010 statute, all it says is a written recommendation. You've seen our argument that the recommendation is only if the neutral evaluator finds that there is sinkhole activity and then makes a recommendation on the fix. In other words, reading it specifically, the 2010 statute, it's to assist in the resolution of confirmed sinkhole cases. The recommendation of the fix comes in. Doesn't matter in this particular case. Mr. James came in, he gave his entire testimony, he gave his data from his investigation, all came in. So what didn't come in? The word neutral, and that's it. That cannot be the basis for a reversal, and it shouldn't be the basis for justice in our system. In fact, in voir dire, if the court allows a witness to be called neutral, I spend a considerable amount of time in voir dire talking about the fact you're going to hear from a witness with a title neutral. Does anybody, just based on that alone, believe that that witness is entitled to greater weight? If they say yes, they're stricken for cause. Well, that's if you have a trial judge that lets you try your case on voir dire, but...
No. Well, it's the same with police officers, or if I have an auto case, it's a chiropractor or an orthopedist, you're going to give more weight to a particular witness. You're not allowed to give more weight to a witness based on the title. And the entire testimony came in. The full report that he had, this is the data, it all came in. His, quote, full report is 2 pages, most of which lists what he reviewed, and in one sentence he says, I do not believe sinkhole activity is present. He testified to every bit of that, every bit of it. And can you imagine the mischief that may occur if they're right and the neutral evaluator's full report comes in? What they're saying, it doesn't matter what he puts in there. He can put things about witnesses, the other side's witnesses, anything they want. According to them, the whole report comes in. Well, that's not any system of justice. And that's certainly not what's intended in this case. And I don't know that the 2011 statute, which is after our policy period, would even apply in this particular case. There was no ruling on that. If Judge Perkins had said, look, I'm bound by the new statute, I'm required to introduce this evidence, I as a judge don't have any discretion whatsoever, that would have resulted in a constitutional challenge that I would have brought up afterwards. The Betrega case, which is a second DCA case.
The statute was challenged constitutionally, and the court found it to be constitutional in the State Farm case, didn't it?
The State Farm versus Betrega, the second DCA said, well, actually it was Cruz versus Cooperativa de Seguros. The court said subsection 11 is constitutional. That's the stay, the automatic stay, said that's procedural and that's constitutional. However, in that opinion, it said subsection 13, which is what they're citing, subsection 13 is substantive. and it said that. As to the admissibility of evidence, it is substantive. And so there can't be a retroactive application in this case, and there wasn't. He did not retroactively apply the statute. So I think with all the evidence that came in, there was no error, but if there was, there is no harm. Let me go to the verdict form, because that gets into the last question on the efficient proximate cause. Timing-wise, Salke came out after we submitted our brief, and they dealt with it in their brief. This is not a multiple cause case. When you look at SIBO, it says, there is no dispute in this case that there was more than one cause of the loss. And that was defective construction plus Wilma. Then you look at Salke. The Salke's expert witness acknowledged that the reclaimed mine contributed to the damage, but he testified sinkhole activity was the most substantial factor. Totally different case. Our case is, essentially, there's a big crack in the back of the house. They said it was organics. We said it was sinkhole activity, and that organics played no role whatsoever. So there is no multiple cause. I guess their position is the jury could have combined the two. Not possible. There was no testimony in this case that that occurred, nor was there any testimony that that's even scientifically possible to occur. They were given a choice of all or nothing, organics or sinkhole activity. But once they got past that issue, you go to question 2 on the verdict form, and I retained the burden of proof for this question. What is the total amount of damages, if any? They still could have put 0. Plaintiffs proved, by the greater weight of the evidence, was caused by sinkhole activity. So I retained the burden of proof in the jury instructions and on the verdict form to prove the amount of damages caused by sinkhole activity. And the only evidence we put on was the subsurface remediation plan, which was at 30 to 50 feet down. And so their argument's illusory. There was no multiple cause, nor did we seek any damages whatsoever that are even arguably caused by organics. Their testimony was the organics were in the top 2 to 3 feet. Our subsurface sinkhole remediation plan was at 30 to 50 feet. Totally separate, nothing to do with each other. And so when you look at the verdict form, we have that burden to prove the amount of damages. If they wanted to come in and say, no, part of the damages, it's not 166 or 590, it's less because organics play some part of it, they still had that ability. But that wasn't the evidence in this case. Plus, Salke came out, so Salke comes out after our brief. This court, in a case which I lost last year, here, Liberty Mutual versus Martinez, says when independent covered and non-covered causes of loss combine to produce a loss, the loss is covered under the concurrent cause doctrine. And Judge Lambert, you also wrote an opinion adopting concurrent cause under a homeowner's policy, but it was a liability policy.
What was that?
It's a name I can't pronounce. And I was going to submit these that say, had to do with a homeowner's liability policy. I thought that probably wasn't applicable, although it did adopt the concurrent cause standard. But if you search the annals of the 5th ECA, efficient proximate cause does not show up anywhere. It's not a doctrine that the 5th follows. And SIBO, which is the progeny of Salke, was argued in front of the Supreme Court in September, and so we'll see where that shakes out. It just doesn't apply in our particular case. Let me see. Unless you have any other questions on the underlying case, I'll go right into the attorney's fees.
Yeah, go ahead.
Okay. Now, the facts are a little bit different than Lambert World was, and slightly, only slightly, in that they found Mr. Bernardini. Mr. Bernardini takes the case, files the lawsuit for sinkhole loss.
And and you represent in your brief, he's a board-certified civil trial lawyer.
He is.
So it's not like I went to a probate lawyer and said, oh my goodness, what am I doing? And
You are correct.
Okay.
And he's been around here for a long time. He took that case, pursued it, got a little too,
And you agree there's no evidence in our record that he required a multiplier to take the case?
in his fee agreement, the record contains no evidence of
And there's-
his fee agreement.
Yeah, he didn't testify at the attorney fee hearing, and Mr. MONE didn't say, well, that was the arrangement I had with him either, so.
That is
And
correct.
apparently, Mr. Bernadine, or however he said, referred the case to you.
Yes, sir.
With the consent of, he said the MONE. So
Yes.
that's how you got in, and then you said, you have your agreement, and it talks about the multiplier.
Yes, so contingent fee or court-ordered fee, whichever is greater, which allows for the application of multiplier. And so their position on that issue, I could not have done anything more. The evidence in the record is, all we got to show is competent, substantial evidence to support the award, this is something that, type of case that I handle routinely throughout Florida. There are very few of them on the eastern side of the state.
Well, let me ask about that. So if this was a Tampa case?
Tampa.
I mean, you know, when we talk about, you know, as we're talking about federated, that Judge Cohen and I were on the panel, the application of the multiplier is the exception, not the rule. Presumptions overcome only in rare and exceptional circumstances. So that's citing to a U.S. Supreme Court case and a third DCA case. So this case then has to be one of the rare and exceptional circumstances, right?
And it is.
Okay,
Yes,
and
sir.
if it was there seemed to be some inference, and correct me if I'm wrong, that if this was a Tampa case, Hillsborough County, which sounds like it's a wash and sinkhole world over there, that multiplier would not be appropriate in those cases in that location because they're not rare and exceptional cases, or no?
I would just say it'd be totally different geology. And here's what, on the east side, and this is the evidence, on the eastern coast, I've tried 3 East Coast sinkhole cases. I lost 2 of them.
Was this an East Coast, West Coast?
It is. It's East Coast, West, because the geology here is shell, and so the dissolution of shell is a much more difficult concept to, when you have to have the dissolution of limestone or a similar rock formation. The other side comes in and says shell is not a similar rock formation. It's just much more difficult. Mr. Tyler, of the 5 cases, sinkhole cases he had tried, one of which was here, he lost 3 of them. They're much more difficult on the East Coast. And so we have 3 attorneys, really 2, who do these cases on the East Coast, Mr. Tyler, myself, and another lawyer who refers them, or co-counsels with Mr. Tyler on those cases. And so it comes in, and suit's already been filed before any testing is done. That's a difficulty from my perspective. But the things we look for in a sinkhole investigation are what's going on with the borings. There's called standard penetration tests. Is there weight of rod, weight of hammer, loss of circulation? None of that in this particular case. On the West Coast, we have those routinely, which changes the dynamics of the case greatly. We have a floor elevation survey that is not very much out of tolerance. These are all important factors to look at and determine, do I have an easy case or tough case? All the evidence in the record is that made this a very difficult case. Miss Brown, if the court had adopted Miss Brown's testimony, there would be no evidence here to support her testimony, none. It was pure opinion and speculation. She didn't talk to anybody. Our experts did talk to local people who do first-party cases, and they say this is not the type of case we
You had
take.
no trouble finding experts who testified that it was sinkhole damage, did you?
I had Mr. Galati and Mr. Nettles. They looked at this and said that it was sinkhole activity. Yeah, that is true.
So, you know, if you know, these cases are battles of the experts. And, you know, and there's no evidence in this record that as the attorney, you had any difficulty in you know, finding experts who would support your position, and then you present it to the jury, and either the jury believes it or they don't believe it, which is, you know, similar to a mail case. You've got experts on both sides. The jury makes the call.
I would say a little bit different. The Joyce case, the Federated case that you've been talking about, was a case where the suit was filed, the defense realized immediately that there had been a mistake on the application, the information hadn't been given to Federated, it got flipped, and no trial, nothing like that. I had experts. The difficulty is conveying those opinions in a convincing fashion to the jury, which is why these are such difficult cases, especially on the East Coast.
Isn't it that-
Oh, go ahead.
I'm sorry, if you do the same type, this is a small world of litigation, I imagine, the sinkhole world.
It is.
And so aren't there sort of a known number of experts that do sort of specialize or focus their practices on sinkhole activity related cases?
There are, on both sides. On both
I was going to
sides.
say, there are some that lean to the defendant, some that lean to the plaintiff.
The number on the plaintiff side is exceedingly small, exceedingly,
Would it be
the
fair
number
to
of
say that you
experts.
probably you knew Mr. Gulati
Oh, yes.
before he testified in this particular case?
I did. And I knew ultimately, Mr. James' testimony was that they wanted to call him neutral. They did better than that. They called him a plaintiff's guy. Mr. James said no sinkhole activity because of the shell concept in this particular case.
But he seemed to have been well cross-examined.
I believe he was. So and that goes to the harmless error. There's no harm.
So the homeowner was awarded $166,000. How much did you get?
Today, well, we got it reduced to the amount of the policy limits, so I want to make that clear. So the policy limits are less than that, so the judgment itself was less. To date, I have been paid zero for costs and for fees. They need that money. The cost to repair is greater than the policy limits. They're going to need that money to repair their home. So the only source of recovery for me is through the 627,428 fees and costs. And that's an important point because the purpose of the multiplier is how do you compensate for the risk of non-payment? There is a great risk of
But
non-payment.
it's not viewed from the, other than the client's ability to secure counsel, it's not, well, they need the money. That's not the multiplier concept.
The client does not get the money. It's how do you compensate the lawyer for the risk of non-payment? That is the
But
purpose.
I'm just saying, though, that your argument, well, the homeowner needs, rather than me taking my fee,
yeah.
that they need the money to repair, that's not the issue.
I can tell you, my contract allows me to take 40% of the recovery plus my costs, at which point they'd owe me whatever it was, $15,000 over and above what the recovery is. I don't do it that way. I'm going to rely on the court, hopefully to affirm, and then the fees will be 627,428. So I'm not taking their money.
Let me ask you how you get around the language that Judge Orfinger wrote in Schultz. And I understand Schultz is a PIP case, and I understood what he made reference to the concept of PIP cases, and you discussed that in your briefs about PIP versus a sinkhole case. But he writes that Mr. Schultz did not testify at the fee hearing. We have nothing to suggest that he had any difficulty obtaining competent counsel to pursue his PIP claim. And I understand here your client did testify, so that's a distinction, but it was without a difference because your client did not testify that he had difficulty retaining counsel, competent counsel. And Judge Orfinger writes, in our view, that lack of evidence alone may be fatal to the claim of a multiplier. So, I mean, in the context of your case, or Mr. and Mrs. Monet's case, they have a claim, they go talk with a board-certified civil trial lawyer who they retain. He files a lawsuit, and eventually it goes to you, and you finish the job, and you certainly have a 262,000 something lodestar, so you are going to be compensated. And now we're just talking about the bump here, the 1.5 multiplier bump. If Judge Orfinger, on behalf of this court, viewed that lack of evidence alone to be fatal to the claim of the multiplier, explain to me why that ostensibly shouldn't be fatal here, because we don't have any evidence that it was difficult for your clients to obtain competent counsel to pursue this sinkhole case.
I think it's really an easy answer. In Schultz, it says hundreds, if not thousands, of these cases inundate our dockets. It is clear to the court, with their own, based on their own experience, that there is no difficult obtaining counsel to handle routine PIP cases, is how and what they described it as. Then he went on to say it may. That case then got resolved. There was no trial. And so now differentiate it between that case and this case. There are some sinkhole cases that arise and come up to this court every once in a while. Very few of them. I'm sorry?
I guess
Got
we're
two
just
this
lucky.
week.
2 this week?
We had one on Tuesday, and they didn't get there was no multiplier.
Well,
What are you gonna do? What are you gonna do, eh?
you got to cross your T's and dot your
Right.
I's and get competent, substantial evidence. And so the difference is that there are very few, and there are very few, I think, that go to trial here. There are more and more because the insurance companies are seeing that they have a success in these cases, especially on the East Coast. And so that is, I think, the main difference. I think there was underlying that case, there was more.
Is it your feel from reading Schultz that if the PIP case actually went to trial, that might not have, the result may have been different?
I don't think that would have been. I think there was more going on with that case than meets the eye. I think the court was concerned about the number of PIP cases and the award in that case.
And admittedly, the underlying, it was a $1,300 resolution, and what turned out to be a $193,000 fee based on the 2.5 multiplier, and that, they talk about how there's judicial consciousness being shocked, et cetera. And,
Yes, sir.
and you don't quite have the differential between the verdict here and your fees that they had at Schultz.
Getting back to whether your daughter ought to go to law school,
She should.
there are, the number of lawyers, today, it's expanding. We've got a zillion law schools in Florida. And Quanstrom is back at a time when there weren't as many lawyers, and isn't really the issue, can you get competent counsel to take these cases?
I'll answer. I want to make sure we don't lose the focus. The purpose of the multiplier is to compensate counsel for the risk of non-payment. So that's overarching the purpose. And then the answer to my question is, absolutely you need it. I do not know, these are very difficult cases to try. Geotechnical engineering, structural engineering, geology, and construction.
The lawyer that she called took the case.
I'm sorry?
The first lawyer she called took the case.
The other,
Or, your client, the first.
well,
Mr. Bernardino.
but he wasn't willing to pursue it either. He took it and immediately realized, wait, I'm in over my head, and then got it to me based on reputation in the community. And so that is a case that, the type of case that I take, I do not ask for a multiplier in every single case, every single first-party case, and I routinely testify as an expert in attorney's fees hearings and say no for homeowners or...
None of that's on the record, Mark.
Right, I know, that's fine, fair enough. But it's a very difficult case where you're going to expend hundreds and hundreds and hundreds of hours and usually about $100,000 in costs. Not many lawyers are going to do that. Not without the opportunity to be compensated for the risk of non-payment.
So you're saying that you should not be punished because the Monets were fortunate enough to initially retain counsel who knew you.
Correct.
And
That's just not the
immediately
standard.
flipped the case to you
As
because
I-
he knew that your reputation.
Yes, and that's not the standard. So the goal is to compensate for the risk of non-payment. The only evidence in the record is there was a great risk of non-payment. And then look at the facts of the case. I forget how many hundreds of hours I have in the case, and
218.6.
total, just for me, not only, then my associates who are more.
Let me ask you, how do you square the comments you're making about the East Coast, sinkhole claims with the trial judge's findings in the final judgment that you want us to affirm on the fees, that it was a greater than 50% chance that you were going to prevail.
He said that, did you read was it in the are you reading from the record?
Oh, I'm reading from the I understand his, well, let me rephrase that. I have read what he has said as to how he got to the 1.5 multiplier, but I think when we actually read the judgment.
I thought, he said the facts were such of the case, the actual facts of the case were such that I had a less than 50% chance of success at the outset, but then he threw in, which I guess is a compliment, a very unique factor, the fact that I was the lawyer knocked it down to less than 50% chance of success at the outset. I don't know that that's a factor at the outset, but that's what he said.
You know, sometimes we have to note irony when catch cannons on here. But I mean, I thought he, given the facts of this case, the court finds that at the outset of the handling of the case, plaintiff's chances of success were greater than 50%. So that's kind of...
Right before that, he said that it was less than 50%.
Well, I'm actually reading from the judgment. I understand in
okay.
the transcript he was kind of got this stream of consciousness discussion was going on, but when he put it in writing, that's what he said. But in any event, well, let me ask you about, your opponent wants us to certify this regarding the SAWGRASS. Under Petty, the second DCA's opinion in Petty, they seem to suggest that, you know, this type of case, under this statute, it is a kind of a penalty for the insurance company for not settling the case or resolving this case. Why shouldn't we certify again regarding SAWGRASS to have them see if they'll reconsider, the Supreme Court will consider whether these cases are multiplier type cases?
Couple of answers to that. First, SAWGRASS said they differentiated between 627.428 and 768 when they said the issue is, do you need a multiplier at the outset? At the outset, to obtain competent counsel. When you have a proposal for settlement, they've already taken the case, the proposal's filed later. So they distinguished the two. But just recently, and I filed this as supplemental authority, March 24th of this year in Patton v. Geico, where the Supreme Court of Florida is talking about whether or not the policyholder can obtain the time records of the insurance company's lawyers. And here's what the Supreme Court said just in March, in this case. The hours expended by the attorneys for the insurance company will demonstrate the complexity of the case along with the time period and may belie a claim that the number of hours spent by the plaintiff was unreasonable, or that plaintiff is not entitled to a full lodestar computation including a multiplying factor. It then cites Palma, and this is again March, cites Palma, where it says, underlying the case was highly litigated and the risk of non-payment justified the use of a multiplier. That's March of this year. The Supreme Court then goes on and talks more about multipliers in 627.428 cases. They're not in any mood and have given no indication whatsoever that they are willing to readdress this issue. I think it's a false, I mean, it's not even an issue, because in SAWGRASS, they distinguish the two. And in Quanstrom, they certainly talk about 627.428.
Yeah, Quanstrom was, a long time ago.
There's still the great risk of non-payment, and still these are difficult cases that very few lawyers are willing to take.
Quanstrom came sort of on the back of the Delaware Valley cases out of the U.S. Supreme Court, and then subsequent to Quanstrom, Justice Scalia wrote an opinion, City of Burlington versus Dague, D-A-G-U-E, where he was talking about why fee-shifting statutes shouldn't have the multiplier here.
I think after that... I know it's not apples to apples, but, he seems to make points why multipliers aren't appropriate in fee-shifting post-Quanstrom. And none of those have been adopted by the Florida Supreme Court or the appellate courts. Now, some of the appellate courts are dancing around some of the issues. I agree. This court has not. Factually, in Joyce, you pointed out the reason why in that case a multiplier would not be appropriate. This case is totally different than that, completely. And economically, and we have testimony in the record, This doesn't work because these cases are so expensive, so time-consuming, and so difficult. This doesn't work for homeowners. They will not obtain competent counsel if or counsel is not compensated for the risk of non-payment. The risk is too great.
You know, you say that, but I don't know that that's a,
Here's what'll happen. People will take the cases and they'll settle them cheap. They will not take the risk of investing, I think it was close to 500, if not more hours total for the firm, and $100 and something thousand in costs. They will not take that risk and go to trial. They'll settle it for whatever they can get and be done with it. So it's that risk, which is real.
John Morgan wouldn't do that. I know John Morgan, he wouldn't do that.
Well,
Any further questions?
I appreciate your time. Good questions. Thank you.
Thank you, counsel. Okay, counsel, you have 5:52 in rebuttal.
Thank you. First of all, Judge Cohen, I'll answer the question directly that you asked my opposing counsel, and that was how much the award was. It was $393,930 was the fees award. There was another $110,000 in costs. $131,310 was attributable just to the multiplier. So I thought it was important to have that in the record, and for Your Honor to get that answer to that question directly. We have here a significant multiplying amount, and Your Honor, it's not a punishment to deprive an attorney of a multiplier. You suggested that it would be a punishment. The multiplier is a mechanism for fee shifting above and beyond the fee shifting that's built into the statute. The reason why denying a multiplier is not punishing a counsel. Giving a multiplier is to recognize those instances, most significantly, where a client would not have been able to obtain competent representation absent the existence of that multiplier. As you know, Judge Lambert, you pointed out the fact that the judgment itself noted the greater than 50% chance of success. And I still look back at this court's, again, Your Honor, and Judge Cohen's decision federated. As one would anticipate, given today's legal market, there was no evidence the Joyces had any difficulty obtaining counsel to handle this matter. Indeed, it took only one phone call for the Joyces to secure counsel. While we review the trial court's decision for an abuse of discretion, we are not required to abandon what we learned as lawyers or our common sense in evaluating the reasonableness of an award.
Boy, that's very well written.
It was outstanding. It's an outstanding quote, Your Honor, and I enjoy reading it back to you because it's right on point in this case. The evidence is what the evidence is. You heard Mr. Nation describe the complexity of the case. You heard Mr. Nation describe how difficult it was. That's recognized by the hourly rate. That's what all of the cases talk about. For example, in Florida Compensation versus Roe, the novelty and difficulty of the question involved should be normally be reflected by the number of hours reasonably expended in litigation. And in the Middle District of Florida, Adviano, talked about the fact that the number of hours, the lodestar, is typically and ordinarily sufficient compensation because that is what identifies the recognition of the specialization, the recognition of the complexity. $600 an hour is a significant rate that has not been challenged on this appeal. The multiplier here, however, was not appropriate. It just was simply not appropriate in light of the evidence presented. I do also believe that, and again, from the perspective, I believe that it is prudent to certify this question again and hopefully obtain some guidance on this question of is a multiplier even appropriate when there's this statutory basis for awarding fees. Now,
They issue a show cause order to us while we keep certifying questions that they don't want to, they continue not to
eventually,
answer?
you know, Your Honor, I think that if the court found as a matter of law and held that it was not applicable in this context, and then certified it, then the Supreme Court might take the case.
Judge Lemonitis is the one who signs the opinion.
I do want to point out, I'll kind of go backward in reverse order. I'd like to talk again about the efficient proximate causation doctrine and then finish with this neutral evaluation issue. On the efficient proximate cause doctrine, I want to make clear from what I've reviewed of Salke, the Salke decision does not require the expert on behalf of the insurance carrier, for example, in this case, to acknowledge that there were other causes of potential harm. In that case, as I understood it, it was the Salke's expert, who acknowledged that other aspects of this damage to the property could have been attributable to something other than sinkholes. There was some testimony in this record, I'm looking at page 929 of the record, where I believe it was their expert Gelati who talked about the fact that if there were cracks in the house that developed in the first 3 years of the house, that could be shrinkage, that the damage could have been ongoing. But as for the exact timing of the crack, I do not know. Question: so you're telling this jury the crack could have been caused by shrinkage? Answer: I said if this crack was there in the first 3 years. That's what I'm saying. My reason for presenting this to the court is in listening to the back and forth in the questioning and answer. To the extent there is this question of under the efficient proximate causation doctrine, there has to be some evidence from either side of an acknowledgement that there might be more than one cause. We do have that in this case because there was some lack of certainty as to when certain cracks appeared in this house. I stand, however, by my original argument that if you've got one expert saying that there is a sinkhole and the other expert saying no sinkhole, it's a question of fact for the jury to decide who they believe, and if they believe under the efficient proximate causation doctrine that the sinkhole, the majority of the damage was caused by something other than sinkhole, then the jury should be given the instruction that gives them the opportunity to find no sinkhole damage and therefore no coverage under the policy. And finally, the issue of the neutral evaluation. Your Honors, the neutral evaluator is mutually selected by both sides.
For that?
I'm sorry, Your
What's
Honor?
your best case to support this argument?
Your Honor, I cited to the Mejia case, which is a case they relied on very heavily. And that case, I think, is excellent for us because it highlights the importance of demonstrating the bias based upon relationship between an expert and the party that brings the expert. I believe the corollary here applies from the perspective of prejudice, from the perspective of how Sawgrass Mutual was prejudiced. They could have stricken the neutral evaluator. They had the right to not accept the neutral evaluator. And I would question, if the title doesn't matter, if it means nothing, why did the plaintiffs fight so hard to keep it out? The plaintiffs had a reason for moving in limine to exclude him. They fought very aggressively not to have him be identified as a neutral evaluator. If it means nothing, then why are we standing here arguing about it? That's my hypothetical. I'm not asking the court to
Because
consider, of course.
it's one thing to present experts, it's another thing for the court to put its imprimatur upon, the characterization of a witness's testimony.
And
Why?
I understand the point, Your Honor. It's not the court, it's the legislature, and I believe the court must fulfill the legislative intent here. It is the legislative mandate that must be fulfilled.
Okay, counsel,
Thank you
very
for your
much.
time today.
Well argued case.
Thank you.
Very well done. We enjoyed it.
Thank you.
Thank you
All
for
right,
your
we will
time.
now stand adjourned.
After, with the following two words, med school. There you go.